Good morning. My name is Utkarsh Yadav and I am Assistant Professor, School of Law, Galgotias University. Today we will be discussing the module Criminal Code Process. In this module, we intend to discuss the process undertaken by a court to adjudicate a criminal matter. Here we would be discussing as to how the criminal justice system is set in motion, that is how one can invoke the criminal justice system. Secondly, what are the agencies involved in the criminal justice system? And finally, what is the trial process in the criminal court process? But first and foremost, the statute that will be at the center of our disposition, it is the Code of Criminal Procedure 1973. The Code of Criminal Procedure, hereinafter CRPC, falls within the realm of procedural laws. We understand that there is a difference between procedural laws and substantive laws. The substantive laws, they give us or they define rights, whereas the procedural laws, it lays down the machineries to implement those substantive rights. So we have substantive laws which gives us our rights, and we have procedural laws which implement those rights. And Criminal Procedure Code or the CRPC falls within the realm of the procedural law. We also have to understand as to what are the agencies that are involved in the criminal justice system, and there are three. The first is the police, the second the prosecutors, and finally the judges or the courts. All of them are very integral to the criminal justice system and perform very important functions. Let's take the first agency, the police. The primary task of the police in the criminal justice system is to register the complaint, number one, and then to investigate the matter. So whenever an offence has been committed, any person can approach a police officer and get the complaint registered. This is known as FIR, which we will be studying in the later part. So it is incumbent, it is the duty of the police officer to register the complaint which he has received by any person. One thing which also needs to be stated here is that any person can go and register the complaint. Therefore, the rule of locus standi is not applicable in criminal proceedings. Even if that person is not aggrieved, he can approach a police officer and get the complaint registered. So, a police officer has to register a complaint and then he has to investigate the matter. These are the two very important functions of a police officer or the police. Number one, to register a complaint and then to investigate the matter and then to finally submit the findings of the investigation to the magistrate. The second agency that is involved in the criminal justice system are the prosecutors and the defense counsel. The duty of the prosecutor is to establish the charge against the accused person. Any accused person would be charged with a particular offence, and it is for the prosecution to prove the charge standing against the accused person. This is a burden on the prosecution, this is a responsibility of the prosecution, and it never shifts. The burden of proving the guilt of the accused person lies on the prosecution. On the other hand, we have the defense counsel, which argues or which defends the case of the accused person. The third and very important agency involved in the criminal justice system are the judges, the courts, or the judiciary. We have to understand their role, their functions, and their power to completely understand the virtues of criminal court process. But before doing so, we have to understand that there is a difference between adversarial criminal justice system and inquisitorial criminal justice system. The Indian criminal justice system is modeled on the adversarial criminal justice system. There are three important attributes of the adversarial criminal justice system. Number one, the accused is presumed innocent unless proven guilty. Secondly, the burden of proving the guilt of the accused person lies on the prosecution, and this burden never shifts. Thirdly, and most importantly, that in the adversarial criminal justice system, the judge, he sits as a neutral umpire. He does not take active interest or active involvement in the criminal trial. He participates or interferes or intervenes only when it becomes imminent. Therefore, the role of the judge is to act as a neutral umpire, to hear both the sides clearly, and then to adjudicate. In order to effectively understand the criminal court process, we have categorized it into two stages: the pre-trial process and the post-trial process. However, before proceeding to discuss the processes in the criminal court process, we must first understand the administration of courts in India. Section 6 of Code of Criminal Procedure, it categorizes the criminal courts. At the top of the hierarchy, we have the High Court, followed by courts of session. Then we have judicial magistrates first class and metropolitan magistrates as well. Then we have judicial magistrates second class, and then finally we have the executive magistrates. Now, we must first understand the power and the role and the position of the High Court. High Court is the highest court exercising criminal jurisdiction in a state. It hears appeals from district courts, though it has original jurisdiction in some matters, but predominantly it is for hearing appeals from the district courts. It can pass any sentence authorized by law, including the death penalty. But the most important functions that it performs is that it exercises administrative control over the district courts. So all the district courts within a state are within the administrative control of a High Court. The next courts in the order of hierarchy are the courts of sessions. This has been discussed under section 9 and section 10 of CRPC. Courts of sessions are established by state's government in every sessions division. We must understand that the CRPC categorizes every district in a state into one sessions division, and for each of the sessions division we have a sessions judge. The sessions judge is the judge who presides over the court of sessions. The court of sessions is subordinate to the High Court, and it can pass any sentence authorized by law, but a sentence of death has to be confirmed by the High Court. The next court in the order of hierarchy is the courts of judicial magistrate first class or the metropolitan magistrate. Judicial magistrate first class or metropolitan magistrates, they are appointed in every district by the High Court. The senior most judicial magistrate first class is designated as the Chief Judicial Magistrate. He heads the magistracy in the district. The High Court may also appoint additional magistrates in any district in order to assist the Chief Judicial Magistrate. The Chief Judicial Magistrate can pass any sentence authorized by law except a sentence of death or life imprisonment or imprisonment exceeding 7 years. Additional magistrates can pass any sentence of imprisonment not exceeding 3 years or a fine not exceeding rupees 5,000 or both. Judicial magistrates second class, they are again appointed by the High Courts and they can pass any sentence of imprisonment not exceeding 1 year or a fine not exceeding rupees 1,000 or both. In administration or organization of courts, we have seen that it is the High Court which is at the top of the hierarchy, followed by Courts of Sessions, followed by Chief Judicial Magistrate who is assisted by other magistrates, and then we have magistrate second class. This is the organization or the categorization of courts in the criminal court process. After understanding the categorization of courts in the criminal court process and the agencies involved in the criminal court process, we may proceed to discuss the trial process. This has been categorized into two categories. Number one, the pre-trial process, and secondly, the trial process. We would first discuss the pre-trial process. The pre-trial process would be discussed under four heads. Number one, registration of FIR. Second, investigation. Third, arrest, search, seizure, and lastly, remand. Let's first look at registration of FIR. Registration of FIR is provided under section 154 CRPC. FIR, that is the first information report, sets the criminal law in motion. It has very important bearing on the criminal court process. Whenever a cognizable offence is committed, any person can approach a police officer and give him information regarding the commission of the cognizable offence. The police officer receiving such an information has to mandatorily register the FIR. He has to register the complaint and give a copy of that complaint to the complainant or the person who has come to register the complaint. However, if the police officer refuses to register the complaint, then the aggrieved person can approach the superintendent of police for necessary directions. What we also need to understand is that a police officer is bound to register an FIR whenever he receives an information with regard to commission of cognizable offence. There was some confusion as to whether a police officer can, before registering an FIR, embark upon a preliminary inquiry so as to ascertain the veracity of the facts, or he has to mandatorily register the FIR. This problem had arisen because there were two lines of interpretations by the Supreme Court with regard to section 154. One line of interpretation, it enunciated the view that whenever any information with regard to commission of cognizable offence is received by a police officer, he has to register the FIR. It is his statutory duty to register the FIR and he has no discretion in refusing to register the FIR. However, there was another line of judgment which said that in order to ascertain the veracity of the facts, a police officer can embark upon an inquiry before registering the FIR. So, it authorized the police officer to conduct a preliminary inquiry before registering the FIR. However, this controversy has been settled by the Supreme Court recently in the constitutional bench pronouncement of Lalita Kumari versus State of UP, wherein the Supreme Court has categorically stated that it is the statutory duty of a police officer to register an FIR and he has no discretion in deciding whether or not to register the FIR. However, when the offence is predominantly of civil nature or it is a matrimonial offence, then in those cases a police officer can conduct a preliminary inquiry. Otherwise, in normal IPC crimes such as murder, kidnapping, abduction, rape, dacoity, etc., the police officer has no discretion and he has to register the FIR. Now, what is the nature of FIR? Is it a substantive piece of evidence? FIR is not a substantive piece of evidence, though it can be used to contradict or corroborate the maker. By substantive piece of evidence, we understand that any evidence which can be used solely for the purpose of convicting an accused. An FIR is not a substantive piece of evidence. However, it can be put to the limited use of contradicting or corroborating. Then courts attach great importance to lodging of prompt FIR. If there has been any delay in lodging FIR, it has to be explained. Then a person, instead of approaching a police officer to lodge an FIR, can also make a complaint directly to the magistrate. So any person who has information with regard to commission of any offence can either approach a police officer to register his complaint, and that will be the first information report, or he can also approach a magistrate directly to register his complaint under section 191A. A magistrate is empowered to accept a complaint and he can order the police to conduct investigation on the basis of the complaint. This takes us to the second stage, that is investigation. This is discussed from section 156 to section 159 CRPC. Investigation has to be done by the police. The purpose of investigation is to collect evidence which can stand the test of scrutiny. It is the statutory right of a police officer to conduct investigation for the purpose of collecting evidence. A police officer can investigate a cognizable offence without an order of a magistrate. However, with regard to non-cognizable offence, such an order is necessary. The investigation, which is done for the purpose of collecting evidence, it culminates with submission of report to the magistrate under section 173 subsection 2 CRPC. So, any police officer who is conducting investigation has to submit his report to the magistrate, and it is on the basis of that report that the magistrate takes cognizance in the case. Another important aspect in the pre-trial process is arrest and search. Arrest is the apprehension of a person by legal authority resulting in deprivation of his liberty. Arrest can be of two types, one made in pursuance of a warrant and other made without such a warrant. The objective or the reason behind arresting a person is to ensure that that person is present to face the trial. If there is no threat that the person will run away, then there is no need to arrest that person. Another important aspect is search and seizure. Section 165 to 166 CRPC authorizes a police officer to make search for investigation. However, this can be done only when there are reasonable grounds for doing so. Another important aspect that we must understand is that the rule of odi alteram partem does not apply to search proceedings. Therefore, whenever a police officer is conducting investigation and in that process is conducting search, then any person against whom search proceedings have been initiated will not get the opportunity to defend himself. If this is allowed, then it will defeat the very objective of search proceedings. For this reason, the rule of odi alteram partem does not apply at investigation stage and more particularly at search proceeding stage. However, if the person has to say anything with regard to the search proceeding, he will be given an opportunity at the time of trial. Another concept which is very important is that of remand. A person who has been arrested without a warrant cannot be detained for more than 24 hours. However, if further detention is necessary because it will aid investigation by the police, then further detention can happen only after obtaining an order from a magistrate, which is known as remand. The objective of remand proceeding is this, that the person who needs to be detained will get an opportunity to present his case before a judge, and the judge will also apply his judicial mind as to whether his detention is necessary or not. Now we move on to the trial process. The trial process can be studied under the following categories. Number 1, cognizance by magistrate. Second, framing of charges. Third, trial. Fourth, bail. Fifth, sentencing, compensation to victims and appeals. Let's take the first stage, that is cognizance by magistrate. A magistrate, when he receives the investigation report under section 173 from a police officer, or he receives a complaint by a person under section 191A, can take cognizance and issue process in the matter. So the magistrate can take cognizance either on the basis of the police report or on the basis of a complaint that he has received from a person. What has to be underscored here is that a magistrate is not bound by the conclusions arrived at in the investigation report. Even though the investigation report suggests that there is no sufficient evidence to proceed in the matter, the judge may choose to take cognizance. Therefore, the magistrate is not bound by the findings in the investigation report and he has to take an independent view of the matter. The choices available to a magistrate are 3. Number 1, he can take cognizance and straightaway issue process. Number 2, he can dismiss the case. And number 3, he can order further investigation. The next stage is framing of charges. This will happen only when the magistrate has taken cognizance of the matter and he believes there is sufficient material to proceed with the case. A charge is the foundation of accusation. The object of framing charge is to warn the accused person of the case which he has to answer. In every criminal trial, there has to be a charge. A valid charge must state the offence the accused person is charged with, the law which creates the offence, and the section of the law and the name of the offence. Further, section 215 CRPC lays down that no error in stating a charge is material unless prejudice has been caused to the accused. Further, section 216 CRPC empowers a magistrate to alter any charge during the course of proceeding. So once the charge has been framed, the trial will begin. The Code of Criminal Procedure, it categorizes trial into 4 categories. A. Trial before a court of session. B. Trial of warrant cases by magistrates. C. Trial of summons cases by magistrates, and summary trials. A court of sessions does not have the power to take direct cognizance of the matter. Rather, the matter is to be committed to it by a magistrate. Now, here we see the trial process. The first step in the trial process is opening of the case by the prosecution. Since it is for the prosecution to establish the guilt of the accused person, the prosecution will state his case first. When the prosecution states its case and the magistrate believes or the judge believes that there is no sufficient material to proceed with the trial, immediately the accused person will be discharged. However, if the judge believes that there is sufficient evidence, there is sufficient material on record which arises grave suspicion against the accused person, then the magistrate will frame charge in the case. After the charge has been framed, if the accused person pleads guilty to the charge, then he will be convicted of that charge. However, if he does not plead guilty and claims to be tried, then the prosecution will produce its evidence. If the accused person does not admit his guilt and claims to be tried, then it is for the prosecution to prove the guilt of the accused person beyond a shadow of doubt. After this, it is for the defense to lead its evidence. When both the sides have led their evidence, then there are arguments in the matter, and finally the judge pronounces judgment in the case. So, any criminal process or any criminal trial will start with the prosecution stating its case, followed by the prosecution evidence, defense evidence, arguments, and finally the judgment. Another important concept is the law on bail, which is discussed from section 436 to section 450 CRPC. Bail is defined as security for the appearance of the accused person, on giving which he is released pending trial or investigation. The Code of Criminal Procedure categorizes every offence into bailable and non-bailable. In cases of bailable offences, bail is a matter of right, whereas in cases of non-bailable offences, it is the discretion of the judge, and this discretion is inversely proportional to the gravity of the offence. If the offence is grave, then the judge has very limited discretion in granting bail. Section 438 CRPC deals with anticipatory bail, that is, bail in anticipation of arrest. Whenever a person has apprehension that he may be arrested for an offence, he may apply to the High Court or the Court of Session for grant of anticipatory bail. And if the High Court or the Court of Session is satisfied, then it may grant the accused person anticipatory bail in the matter. Therefore, any trial process, it will start with the magistrate taking cognizance of the case, then charges have to be framed, then we have the prosecution case, the prosecution evidence, followed by defense evidence, arguments, and finally the judgment in the case. A trial will conclude with a judgment which will either convict the accused person or will acquit him. When the accused person is found guilty and convicted, he has to be punished in accordance with law. Every crime must meet its just deserts, and it is the duty of the judge to punish an accused person who has been convicted accordingly. The sentence must be appropriate and must fit the crime. However, the court may also, having regard to the age, character, antecedents, or physical mental condition of the offender, may, instead of sentencing him to any punishment, release him after admonition or probation of good conduct. This is provided under section 360 CRPC. Another important concept is compensation to victims of crime. Section 357 CRPC empowers a court to pass an order of compensation to the victim at the time of passing judgment. Further, Section 357 ACRPC lays down the victim compensation scheme, wherein adequate compensation is to be paid to the victim by the District Legal Service Authority. Finally, we have the appellate stage. A judgment in a trial court may be appealed to the higher courts. Appeal means the right of carrying a particular case from an inferior to a superior court with a view to ascertain its sustainability. Section 374 CRPC lays down the forums for filing appeals by the accused person. So, if a sentence has been pronounced by a metropolitan magistrate or magistrate first class or second class, then the appeal shall lie to the sessions judge. If the sentence has been pronounced by the sessions judge, then the appeal will lie to the High Court. And if the sentence has been pronounced by the High Court, then the appeal will lie to the Supreme Court. So, this is the entire criminal court process. It starts with registration of FIR, followed by investigation, followed by framing of charges, then the prosecution will produce its evidence, the defense will produce its evidence, there will be arguments, and finally the judge will deliver his judgment in the matter by applying judicial might. Any person who feels aggrieved by the judgment in the case may approach the higher courts by way of appeal. The victim can lay claim to compensation under section 357 and 357 ACRPC. So, this was my presentation on the module criminal court process. I hope you would have learnt from it. Thank you for listening.